In this presentation, we're going to talk about alternative dispute resolution. At the end of this discussion, we will be able to discuss problems with litigation, describe alternative dispute resolution, define and discuss mediation, and define and discuss arbitration hearings. Whenever we have two or more parties that have a dispute and they move outside of the normal court system, the normal process for litigation, the normal adversarial system, that would be some form of alternative dispute resolution system. When we think about the traditional type of system for a court system or type of system for resolving problems within the legal system, we're typically thinking of an adversarial system. We have two individuals or companies or parties that have a problem, and in order to solve that problem, they both argue their side of the problem, give the best points to their side of the problem, and typically have some other individual or court or some other third party that's going to be disinterested in some way, doesn't have a personal stake in the outcome. In order to make a judgment, we give faith to that third party individual because of the fact that they don't have a personal stake in the process, and that we hope that they make the judgment in accordance with how they read or see the fairness of the law that they're going to apply to a certain situation. Now, some pros and cons of that type of system are that the idea, of course, the ideal idea is that two people that are arguing their best point, they're going to do everything they can in order to argue their point. And if they do so through the process of this argumentative process, we will come to a resolution that will be best because two self-interested parties are arguing their case as best they can. Some of the problems with that system will be that because the two parties are so interested in arguing just their case, and they're relying not on their case being completely the best ideal outcome of the case, because they're really relying on the arbitration between the two of them, or the judgment that will be rendered between the two parties arguing their best case scenario to come out with the optimal solution. That could lead to the two parties to go towards extremes in terms of arguments, and it could lead to more types of situations where there's less communication in many cases, because the two parties have basically gone into their own camps and tried to set up everything that they can do in order to prove their case to a third party. So in some cases, that could drive more of a wedge. In some cases where possibly we don't want to do that, we might want to look for some alternative systems in order to settle problems. Other problems with a traditional type of litigation process would be that it is very time consuming and it could be expensive to find the proper litigation. Of course, when we think about this idea of two people or two parties getting together, putting their best case scenario, then words matter. How we put this scenario together matters, and how we align it to the law matters, which means that legal counsel will matter, and therefore there could be a big effect. And so people that have more means could possibly have an advantage, of course, within a system where the system is dependent on argument between two individuals and then finding some ground based on the litigation process. Because of these problems, we could move to the alternative, that being alternative dispute resolution. Some types of alternative dispute resolution can include mediation, arbitration, and summary trials. And this can save time and money in many different ways. The arbitration and mediation can be scheduled very quickly, and they can be scheduled before the lawsuit is even filed. And we also can save times often by setting the appointment without having to set an appointment in accordance with a court calendar, and have more readily available times in order to go through these processes. The process of mediation is going to be a process where we have a mediator. The mediator is going to be working with the two individuals in order to find some resolution, working with both of them to find some resolution to the problem. It is a non-binding process for the mediation process in order to seek mutual resolution between the two parties. It's often a system that can be a bit more intimate, to find a third party who is not involved in either side, doesn't have an invested interest in either side, that typically being an important part of a mediation process, to be reliant on someone that we think is going to be independent in some ways to make some type of judgment, and therefore the two parties being in some agreement in order to agree on the mediator and see if there can be helpful to get some settlement. Oftentimes, the mediation process can be a less formal process in some ways, and therefore allow some people to really possibly do some better negotiation or not be so stringent in terms of how they're going to go about the process for dispute resolution and actually work together and look to find a solution that will be appropriate for the two individuals and not go through the process of a formal court process, which could take up a lot more time and money, which wouldn't be a benefit for either. Arbitration is similar, except that the arbiter is going to be a third party and they're going to have the ability to settle their dispute. So the individuals, the two parties involved, will then call upon the third person who will be an arbitrator. Typically, once again, going to be some type of neutral person, some person that the two parties can theoretically rely on to make a fair judgment in accordance with the facts and the law, and they're going to settle the dispute in the process. So two people sit down, third party is relied upon in order to settle the case and settle the dispute. The arbitration process can also have problems as well. The arbitration process is going to be less formal, will have a less formal process than the civil procedures, and that's typically thought to save time. However, the processes and the procedures can save time depending on the type of case we have. Because there's a less formal structure, it could in some cases actually take more time to put together the arguments and to put together arguments in such a way that they may be worded and formatted not in the same way as a court process would be by the time it got to a court process. And that could actually lead to some cases being extended in an arbitration process, possibly introducing arguments that maybe would have not been introduced in a normal civil procedure process. So because of the fact that we have a bit less rules and a bit more leeway, it could lead to some more complications in terms of how you're going to argue the case within that arbitration process. Another type of alternative dispute resolution, which would be mediation and arbitration, kind of a mix between the two, would be a mediation/arbitration or a med-arb. And that's going to be the idea that we're going to first have the mediation process, which is a less formal process where it's a non-binding process, and see if we can settle the dispute through that mediation process. And then whatever disputes are settled, good. Whatever is not could then be subject to the arbitration process, which would go through that process and have more of a binding decision within arbitration. Another form of alternative dispute resolution is early neutral evaluation. That's going to be a process where the parties permit a referee, a type of referee, to process this, evaluate the case between the two parties and assess the case and the facts in accordance with the law and make a judgment based on this information. So it's going to be a similar process where the two individuals involved are going to make their case and give that to the neutral evaluator, who will act like a referee and come to the decision based on the facts and the law. Another form of alternative dispute resolution is to have a private civil trial. And that's going to be a case where you're going to hire someone who is a professional. You're going to hire a judge or someone who has the process and knows the process of official litigation process. And they're going to go through the dispute between the two individuals with the same rules that you would have for an official trial. So you kind of have the element of having the official trial there. We're going to go through the same process. We're going to go through the same steps, have the benefits of that formal process, but you can schedule it more easily because we're not going to go through the formal court system and have to go through the normal docket system in order to process the court, and therefore it can save time for the individuals involved. Individuals involved who can decide on the judge can be very beneficial as well. If we have two parties involved who know and trust someone that could be a neutral party, or two people want as someone to arbitrate, that could be a factor that would be helpful in many cases to choose this type of technique, a private civil trial. The forms of alternative dispute resolution that we have talked about so far are cases where there's already a problem, there's already a dispute, and we are then picking and applying a form of alternative dispute resolution. Given the fact that there are so many options for dispute resolution, it is possible to take some more proactive steps in order to first say, if there's a party in this particular relationship, we will then go to this particular form of dispute resolution, and that could be a process that will save time. In other words, we can come to the agreement that if a problem arises, we will go towards this form of alternative dispute resolution. It has already been agreed upon in advance. Those types of approaches could include partnering, alternative dispute resolution contract clauses, settlement week, negotiated rulemaking, collective science court proposals, and post-appellate procedures. The concept of partnering is often going to be used when we have a lot of different parties involved in a big project. And if that's the case, then we want to make sure that if there are disputes between the parties involved, that we can handle those disputes in a way that's not going to hinder the total process going forward. So we want to be able to set ground rules on how any disputes will be set within the process of any kind of project that we're going through, where there's a lot of complex relationships going on. An alternative dispute resolution contract clause, an ADR contract clause, is what you would think it sounds like, and that is that the parties involved will then in advance agree to a particular form of alternative dispute resolution if a problem is to occur in the future. This form of alternative dispute resolution then, of course, being an alternative that is in place that we're going to first go to in place of having the normal litigation process. For more accounting information and accounting courses, visit our website at accountinginstruction.info.